Hello, everyone. In this edition of the Ottawa Market, we're to talk about the Supreme Court of Canada. Based upon my background and experience as someone who has a research academic background in constitutional law, I'm not a lawyer, but I do have a background in this area, constitutional law, and in my view, there needs to be a critical national discussion about the role of the Supreme Court of Canada in affirming constitutional rights. Um, in my view, the Supreme Court of Canada has been able to go under the radar of critical national debate and discussion um, because of what Noam Chomsky used to refer to as manufacturing consent, the idea that the media can create a national consensus around viewing some issues as important and some other issues as important. And the Supreme Court of Canada, in this construct of manufacturing consent, has completely fallen under the radar. Um, in terms of the officially, we as Canadians and through our official institutions like to regard the Supreme Court of Canada as being beyond reproach, as being a venerated, important institution, that it does not have the political influences and problems, so to speak, of the U.S. Supreme Court, that rules and decisions are made strictly on the basis of complete neutrality and reverence to the law itself. And in my view, this is a completely sanitized whitewashing of what the Supreme Court of Canada has become. It is very ironic that even though the Supreme Court likes to pride itself as neutral and not having being subject to political influence, it is exact opposite. In my view, the Supreme Court of Canada, through a decision which I like to share, there was some about just over a year ago, made a decision which, in my view, categorically suggests a context of corruption within the modus operandi of the Supreme Court of Canada. There are a couple of problems, in my view, with the Supreme Court of Canada. Again, um, none of these problems have been discussed in any great sense in the Canadian mainstream media. Problem number one with the Supreme Court of Canada is that its justices do not reflect Canadian society. We are a multicultural and a tremendously diverse society. The Supreme Court of Canada's justices do not reflect that. There's been no apparent effort to ensure that. I mean, we have great lawyers from all ethnicities and cultural backgrounds. And the only balance that we see in the Supreme Court to our diversity is a gender balance, so to speak. But as far as diversity lacking, is not that we want to just plot minorities and people arbitrarily and make them qualified judges. The problem is that because of the Supreme Court's lack of diversity, they are not considering critical decisions of concern to minorities in the decisions that they decide to contemplate that are of vital concern to the interests of Canadians. Um, so that's the problem with it, and I'm going to get back to that why that's so important. So the lack of diversity, you know, at least in the American Supreme Court, there's been discussions about diversity, but there's no diversity with respect to the discussions about the makeup of the justices. The second problem with the Supreme Court of Canada is that they can pick and choose whatever decisions it wants to make, you know, particularly in the civil law side. Civil law does not have people who have critical decisions of a human rights nature. They can, there's no right of appeal, and they can just pick and choose. So the decisions. So when you're pursuing an appeal to the Supreme Court of Canada, it is almost the same chance of you being reviewed as winning the lotto, a lotto jackpot. That is how difficult it is to get a decision reviewed by the Supreme Court of Canada. And this, in my view, is problematic. There are many decisions which are not being reviewed by the Supreme Court because if one looks at the decisions that they do contemplate, they are very much driven by certain uh, broad political interests having weight in getting the ear of the Supreme Court justices. We cannot have a Supreme Court of justices that tries to present itself as being non-political, but seems to be highly influenced in the decisions it does contemplate by political considerations. That's the second problem. So a lack of diversity in terms of its makeup, uh, affecting the prism to which the Supreme Court of Justices, what decisions they do contemplate, a lack of a right of appeal, very much political considerations impacting what decisions or what the types of cases that the Supreme Court of Canada decides to rule upon. That's a big that is in fact a big problem. The third issue is that when we have the Supreme Court of Justice, Supreme Court of Chief Justice some months ago, talking about the importance of the rule of law, and that and this is being broken down in society, and we see what's happening in the United States with the breakdown of the rule of law, is quite hypocritical for the Supreme Court of Canada to making references to the rule of law when they do not themselves respect to the rule of law. I'm going to get back to that, and in terms of my own personal experience in the Supreme Court, to underscore that they don't respect their own rule of law, the rule of law in general, and specifically as it applies to even their own decisions. There's a bad need for the Supreme Court to better reflect diversity, and there is a need for the Supreme Court to be more accountable in the decisions that it does contemplate to be reviewed by the Supreme Court. In the United States, much criticized, but at least in the United States, there is transparency. You can know which judges what's the reasons why a Supreme Court of Justice in the United States, why they took a decision, who took decisions, who voted for what, and the process to which Supreme Court of Justices. These are all a part of a national conversation. Again, there's a lot of wrong things happening in the United States, but that is an important feature that is of transparency, which we lack, that we need to start paying attention to. And so that comes back to what inspired my video today. What inspired my video today is what I thought was would be a no-brainer through the Supreme Court, notwithstanding the fact that it's very difficult to get decisions reviewed by the Supreme Courts. In my particular experience, I had a crazy experience where I had a case which was approved by the Commission des droits de la personne de la jeunesse, the Quebec equivalent of the Quebec Human Rights Commission. It was, against the Gatineau police, racist police in Gatineau, who multiple times, stopped me for what, apparent walking while black, which I might contemplate for a different video, but without getting in those incidences, what happened and transpired with the commission. I was before the Quebec Human Rights Tribunal, and all of a sudden, the Judge Catherine Pilon, and the lawyer for the city of Gatineau, right before me while we're in the court hearing process, start speaking to each other in French. And I go, wait a second, how can you start speaking to me? I don't have the sufficient capability in French to understand what exactly they were saying. I objected to this. I said, I look, based upon my understanding of the Supreme Court of Canada decisions in, I believe it was 1994, the Supreme Court of Canada made a critical decision in the case of R versus Tran 1994 that he was a Vietnamese, I believe, and that there was a challenge to the Supreme Court that you know, broke great headway for language minorities, um, and affirmed the right of language minorities to have access to a court interpreter. That was in 1994, the R versus Tran decision. So based upon the R versus Tran decision, I said in the Quebec Human Rights Tribunal, I said, oh, wait a second, you can't just be speaking to me in a different language I can't understand. I have a right to a court interpreter. And they said, oh, well, no, you don't have a right to a court interpreter. This is Quebec. You don't have such a right. We're just going to be talking French among ourselves, and we don't care if you don't understand what you're saying. So as a result of that, in an exchange where the so-called human rights, Quebec Human Rights Tribunal, they were going to be having conversation to each other, which is absolutely outrageous in French between the judge and the city of Gatineau lawyer representing racist cops. To me, this is outrageous. It seems to me that in the most dictatorial regimes, whether it's Russia or China, all these even authoritarian regimes recognize that if you're in a court, you should, even though it may be a show trial in general, they're at least going to respect you enough to have a court interpreter there to make sure that you understand what is going on. So um, again, this is in the Quebec penal side, they do recognize this right under the Quebec Charter, but when it comes to human rights or in any manners that are civil in nature, this right is not being recognized. So I said, okay, I'm going to pursue an interim appeal through, to on behalf of all the people in Quebec who do not have access to a court interpreter and who are denied access to justice, because as a result of the R versus Tran decision, that R versus Tran decision was critical because what it did is that it paved the way for francophones across, not only francophones outside of Quebec, across Canada, having the right to court interpreter, but language minorities across the board having right to court interpreter. I believe in terms of the Ontario Human Rights Tribunal, for example, they empower court interpreters, state-supported court interpreters for about 100 different languages. So, and this is, and if you are going through you're a francophone in Ontario, for example, you have a right to a state and court interpreter based upon the decision of R versus Tran. So this is a right recognized and afforded to francophones outside of Quebec. So, apparently, even though Quebec is supposed to be a part of Canada, Anglophones and people of other language minorities don't have this right, and apparently this decision was skipped Quebec. So here we have a situation where people who are English speaking, you can just simply have the lawyer and the judge, you can just simply be being denied a human rights claim because you cannot understand what is being said. So I said, okay, this does not seem appropriate. I have solid foundations to make an appeal to I took it to the Quebec Court of Appeal. Understandably, they just ignored it because what can you expect from a court that is loyal to the nationalist / separatist pretensions of the Quebec political establishment? So it didn't get far through the Quebec Court of Appeal. So I said, okay, we'll go to the um, Supreme Court of Canada, and if anybody wants to look this up, I invite you to check out file number 40885. I was interviewed by Radio Canada about this particular, my pursuit of interim litigation in terms of the right to a court interpreter that I was seeking to win for people across Quebec to the Supreme Court of Canada. The Supreme Court of Canada deferred it back to the Quebec Court of Appeal because in fact, when I went from the Quebec Human Rights Tribunal and I didn't want to go to the Quebec Court of Appeal because I know it'd be a waste of time. So they said, okay, we can't handle this. Go back to the Quebec Court of Appeal and then you can maybe come back to us. So I went back to the Quebec Court of Appeal, which is very unusual because the Supreme Court of Canada typically does not comment on the decisions, which is also bizarre. They don't comment on decisions. So when they reject you, unlike U.S. Supreme Court, they don't have to give any reasons. So we went back to Quebec Court of Appeal. They rejected. went back to the Quebec Supreme Court. So I felt that, okay, then, so we have a strong case, R versus Trent. So in my view, on paper, it met all the standards of an appeal. It was an appeal which was based upon strong foundations in the rule of law of a Supreme Court of Canada decision that it took place in 1994. It was it had ramifications for people way far outside of my own litigations, for people across Quebec, Anglophones, other people of other language minorities who are being denied potential language rights. I know in Ontario, for example, um, a huge amount of, like, hundreds, like thousands of, a lot of hours is being denied, is being provided rather, in Ontario to court interpreters. So court interpreters in Ontario and across Canada are providing an invaluable service to access to justice. And as a result of this, people who have of all francophone and other backgrounds across Canada are able to understand what is going on in the courtroom in order to pursue litigation, including particularly human rights litigation. So I said, okay, to myself, let us pursue this and let us get this right for people in Quebec. So I had a completely immaculate, even though I'm not a lawyer, I had a completely immaculate interim decision, um, interim appeal presented to the Supreme Court of Canada. And in my view, even though it was very difficult, to go through the Supreme Court of Canada to get them to consider a decision in the judicial review process. It was the fact that my type of interim decision I was seeking had such a wide impact on on people and access to justice. On paper, I should be more than confident in the feeling that, okay, this is going to get reviewed by the Supreme Court, and they are going to decide that people in Quebec who are Anglophones and other minorities, particularly with respect to the Quebec Human Rights Tribunal, ought to have a right to a state-supported court interpreter, just like people outside of Quebec. So, you know, anybody who wants to see how strong of an interim appeal I made, just check out 40885. Contact the Supreme Court, and you'll see the strength of my sought interim appeal. To my surprise, even though my such a judicial review would have a widespread impact on access to justice for millions of people in Quebec, numerous amount of people at least, they just ignored it. They just refrained from taking any decision on it. And now we're back to the environment in Quebec where people who are English speaking, who are going through the Quebec Human Rights Tribunal or the Superior Court or Court of Appeal, don't have a right to a court interpreter, and judges and opposing lawyers, if if your rights have been infringed, they can just talk around you and you not knowing what's going on. So, so again, when we have a Supreme Court of Canada, which lacks minorities on it, they do not have the understanding of people who are disenfranchised and their struggles, and and in order to, and they as a result of that, when they see a case that affects minorities, they just disregard it. Indeed, for example, if we look at Black people, for example, there has not been one, even though Black people suffer greatly as far as patterns of discrimination and racism, the Supreme Court of Canada has not even made one pivotal decision on the type of discrimination that Black people are facing. They just disregard it, and they just not interested. And of course, there's no Black Supreme Court justices on the Supreme Court of Canada. There's no Asian justices. There's no South Asian justices. These minorities are completely absent, so that we don't have any frame of mind among the Supreme Court of Canada to consider minority rights as it applies to access to justice and Quebec of interest. So what the Supreme Court of Canada basically did, what they did was they capitulated to the separatist and nationalist environment which stipulates that um, so-called English-speaking Canada, they play by one rules. We in English-speaking Canada, Ontario, British Columbia, Newfoundland, whatever, we play by one set of rules, and that's the Quebec Charter of Rights. Sorry, that's the Canadian Charter of Rights and Freedoms. And then even though Quebec is the part of Canada, they can play by another rules. They can discriminate all they want. They can disregard Supreme Court of Canada decisions. And so when the Supreme Court of Canada decided that it was going to disregard even making a judicial review of basic fundamental access to justice rights that would have simply affirmed a decision that they already took place in 1994 under R versus Tran. They showed complete hypocrisy. They showed hypocrisy to the Supreme Court of Canada as an environment which seeks to affirm the Canadian Charter of Rights and Freedoms, Canada as a bilingual society, as a multicultural society. They showed hypocrisy with respect to being, concerned about minority rights. They concerned hypocrisy with respect to even affirming the integrity of its own institutions, not its own institutions, but its own decisions. When the Supreme Court of Canada decides that it's going to disregard previous decisions that it already made regarding rules that everybody else is playing by, but one particular part of Canada decides not to play by, that is a serious matter. So when the Supreme Court of Canada's Chief Justice talks about the rule of law, it's completely hypocrisy. It's complete hypocrisy. They are not playing by the rule of law. How could they be talking about the rule of law when they are not affirming their own rule of law with respect to one part of Canada, namely Quebec, completely disregarding tenets of natural justice? In their Supreme Court of Canada, they said that the right to understand the language of proceeding is a fundamental natural right. And when we talk about natural rights go beyond even human rights. Natural right means that it is an absolutely axiomatic principle to any sort of functional judicial environment. It is absolutely fundamental. Natural right is the right that exists as a result of simply functioning and being a sentient human being. That right is fundamental to even beyond the rights that are signed to a constitutional law and a constitutional document, which are legislated. It's complete hypocrisy. So, so in my view, the Supreme Court of Canada disregarding its 1994 decision, allowing Quebec, apparently its courts, to disregard the right of a state-supported court interpreter that all minority language people ought to have in Quebec. This, in my view, shows that the Supreme Court of Canada has corrupted itself by an unwillingness to affirm constitutional law, to affirm once again the R versus Tran 1994, and the rule of law. And we need to have, if the Supreme Court is so willing to disregard what it has already ruled to be natural rights, how can we trust the Supreme Court to affirm constitutional rights, affirm any decision in any manner of integrity if they cannot affirm the most basic fundamentals that of somebody in a court of law in Canada and in Quebec, understanding what is being said and what is being said by the opposing lawyers, what is being said by the court. They cannot even get that right, yet how can we trust them, the integrity of the decisions on anything? And again, this conversation is not taking place because the media, mass media institutions that include Toronto Star, Globe and Mail, CTV, CBC, these institutions do not want this conversation to take place. I contacted these institutions to express my concern about the hypocrisy of the Supreme Court's decisions. They weren't apparently interested. It's because they want to, going again to what Noam Chomsky said, manufacture consent. They want a consent, a manufactured consent process, which views the Supreme Court of Canada as being beyond reproach. They don't want a critical conversation about how the Supreme Court of Canada does not reflect our multicultural society, and as a result of its lack of reflection of diversity, it is not making decisions that are consequent to affirming its very mandate. And when we have a Supreme Court of Canada not willing to support the basic, fundamental, natural right of somebody to understand the language of proceedings in a court of law, as I have continued to experience, we have a fundamental problem taking place in society. And today I'm just simply wanting to alert Canadians that our Supreme Court of Canada is in badly need of a critical national review and discussion, because the Supreme Court of Canada, when the Supreme Court of Canada makes decisions like this, it does everyone a disservice. It shows a lack of integrity. It shows a lack of regard for constitutional rights, a lack of regard to some decisions. And we cannot, in my humble opinion, trust the Supreme Court to be a fundamental arbiter of law if they cannot get a decision like this right and get it so wrong. How can we trust them to regard in the decisions they make at any level? How can and again, I have taken to this media because we cannot trust the mass media to. In the old days, in the 1980s, it would have been possible for us to rely on the mass media to start to review and discuss, what happened to my case and the national implications of that. But in this environment we have an increasing concentrated media that wants to control things with backroom boys and girls with certain interests, that wants to manufacture a consent around its own agenda. Is going to, as a result of that, disregard uh, decisions which it regards to be inconsistent with its own agenda. So again, I look forward to anybody making comments about this video. If you like this type of commentary, like and subscribe. If there's any particular topic you might want me to talk about, I invite you to do so and to inspire national conversation about, just make your comments below. And thanks for watching another edition of the Ottawa Market. And please feel free to make your comments below about whether you think the Supreme Court of Canada is in need of a critical national debate as to its position in the society of supposedly affirming our constitutional rights, but we see pointedly in my particular case that they have not sought to affirm its own mandate to protect our constitutional rights. And I look forward to any comments that you might have in this regard. Thanks for watching.